Hello everyone, welcome back to the show. Well, whether you've been in the workforce for a short or long period of time, you have rights as an employee, but sometimes things happen that may leave you wondering whether you're being treated fairly. For example, could you be required to take a drug test? What should you do if you're sexually harassed? What if you are hurt on the job? If you are an at-will employee, do you have any protection? There are plenty of questions when it comes to employment law, and we are happy to welcome our guest today, who is well-versed in this area, and he's here to help us all better understand it.
Attorney Glenn McGovern has over 3 decades of experience practicing civil rights law, personal injury, product liability, and employment law. Glenn, thanks for coming on the show. We're looking forward to this discussion. Why don't we start with the overriding description? What are employment discrimination claims? Tell us the basic explanation.
People generally misunderstand that. Generally, like was mentioned, you're at will unless you got a contract. Employer can terminate you with or without cause. You can say, I don't like your socks, you're fired. That's it. So generally can do that. But you have to fall under a particular statute to be protected. And basically, they can't discriminate against you under statute, federal and state law for certain things. And briefly, it's like race, creed, color, national origin, sex, smoking, pregnancy, disability, and for whistleblowing. So that's a new hot area.
So if you are an at-will employee, you do have some protections under the law.
Yes, but only in those limited bases.
Very limited.
So if it's personality or something else, you know, which is common, then they can fire you, or you don't friend your boss on Facebook and you get fired. I've had that happen before. You know,
really?
That sort of thing.
Wow,
yes.
that's very
completely legal. Or you're gay and you don't live in Orleans Parish, which has a gay ordinance, but otherwise in state law, federal law, you don't have any protection for that.
It's interesting that there are ballots all over the country about gay rights and the Defense of Marriage Act, really in dispute right now in the U.S. Supreme Court. But let's talk, just make sure that everybody understands, being an at-will employee, that's pretty much everybody unless you have a contract with your employer. Your employer says, I'm going to give you a contract to come work for me for the next year or the next 2 years. Is that what you mean?
Right, that's every state in the union except for 1 or 2.
Okay, so basically everybody who has a boss, that's an at-will employee. And that's pretty much everywhere, definitely in Louisiana.
Definitely in Louisiana. You can be fired with or without cause or a false cause.
So when it comes to complaints, does the size of the business actually matter?
Yes, and that's another thing people don't understand. If I have 3 employees, for example, I can sexually harass or racially discriminate, and that's completely legal. It's not going to violate state law or federal law. Governor Foster raised the minimum number of employees to fall under the state discrimination law to 19. Federal law is 15. So unless they got 15 employees, then Title VII, which prohibits sexual harassment, racial discrimination, etc., doesn't kick in. FMLA may require 50 employees for FMLA to kick in. So each statute has a different number.
Well, you mentioned Title VII, and that's something that we talked about earlier. It's very important to understand what Title VII is.
Yeah, and let's just, and also FMLA, that's the Family Medical Leave Act.
Family Medical Leave Act, right.
But employment discrimination, that is, if you are a mom and pop operation, you're not bound by the federal or the state laws which say you may not discriminate based on race, religious creed, color, and the basic and gender, things like that. Now, if you are a smaller company, it's kind of shocking to hear it, but Glenn practices in this area of law. Mom and pop operations, they can fire you because one day they wake up and they decide they don't like people with red hair. They don't like the color of your socks or your personality.
Right.
They can sexually discriminate against you. Now, if somebody assaults you, well, that could be a criminal violation. You might be sued because of an individual assault and battery, and you could be sued both civilly and criminally. But so we're clear. The Title VII under the federal and under the state, there's another, I don't know what exactly it's called, just state
law, they have a state
employment
statute.
discrimination statutes. If you are more than 19 employees in your company in the state level, more than 15, that's 10 and 5, 15.
Yeah, 15 or more, 19 or more.
15 or more, 19 or more in federal, state, then you are subject to these discrimination laws. Now let's talk about what are your rights if you believe you've been discriminated against. What are your rights?
Well, basically the way it works under Title VII, and state law mirrors it, is what the Congress did is they passed this because after 1964, the discrimination laws, segregation laws, there was a problem. So they said, well, the government can't do it, so what we'll do is we're going to create a little army of U.S. attorneys to go out there, and we're going to give them attorneys' fees, and we're going to award punitive damages so that, you know, this is eradicated in our country. And that's the beauty of Title VII, and it's worked pretty well to change our society as we know it today.
But what do you say to those employees who are watching the show who feel like they are being mistreated, that what is being done to them is illegal, or perhaps the company is doing something that they believe is illegal? What is the first step? What should they do? I imagine, first of all, they're just terrified to have this information and don't even know where to go.
Well, one of the things that's a good topic because that's misunderstood. What you have to do, first thing you should do if you think you're discriminated against, is file a sworn complaint with the EEOC. Now they got a website that you can fill out a form. That doesn't count. You got to file and sign a sworn complaint. Once you do that, you're protected against retaliation. It's a heck of a lot easier to win a retaliation suit, 98% chance of success, versus a discrimination suit. So you may have a case where you can't win on discrimination, but you got a really good retaliation suit. And so jurors don't like that.
And so you should go to the EEOC person there at your place of work?
Nope. Nope, you go to the EOC. HR, you know, it's like, you know, there's a cartoon in the paper with the HR manager, the evil HR manager. You want to file with the EOC, and you only have 300 days in Louisiana.
That's
Some states you have 180
know.
days. That's very important. If you don't file, I can't help you. I can't do anything. You have no federal cause of action. Now, state law, you've got 1 year to file from date of the incident, or date that you know you're going to get terminated, or date you're terminated. So you got to watch that.
Yeah, let me do a little recap on this, because a couple of very important things. EOC,
Equal Employment Opportunity
Employment.
Commission, 1555 Porter Street.
Okay, very important. Okay, you need to just physically go there, ask for the paperwork to file a grievance. Retaliation, retaliatory discharge. That's when your employer finds out you're complaining, you're filing a complaint, or you're thinking about filing a complaint, and then the employer retaliates. Your employer fires you. Happens all the time. I mean, people come see me about this. Glenn sees people about this. If you file this complaint, 98% statistically, the odds are you're going to be in good shape to say, you can't fire me because I recorded my complaint before you fired me. Employers are vindictive. They'll fire you if you're making trouble for them. One more thing, and I want to cover this in a little more detail, this whistleblower business. It's extremely important. If you're aware your employer is maybe not sexually harassing somebody, but they are involved in some illegal operation. Glenn, give us a short definition of whistleblower.
We always interview, you know, people that call in because they may have an employment problem. And part of it may be fueled by many things. One of them may be they complain about doing illegal acts in the workplace, or the employer doing illegal acts. There's a state law and there's a plethora of federal laws that protect workers who report illegal activity. If you know illegal activity, you should report it to a law enforcement agency and to any regulatory agency, and you should report it to your supervisor, and then you're covered. Each one's different. You need to consult with an attorney to make sure you do the right thing. If you're retaliated against, depending on the corporation, if it's a public traded corporation and retaliated, it can be a federal crime. It can be a felony. A lot of people don't understand that. But this is an exciting new area of the law, and for people that, especially people, and there's rewards that are paid to employees, like under the Federal False Claims Act, you can be paid 11 to 31% reward.
Wow, interesting. Okay, we've got more to talk about, so stay tuned. Glenn is going to be with us to take your questions, so stay with us. We'll be right back.